All right. It is 7 o'clock. Hello, Miss Caroline. Hello, hello, hello. How are you? Are you ready? I know you're ready. I know you're excited to take your test soon, and I'm excited for you. Yay! And I just want to make sure that everybody on YouTube can see my iPad. Let me update my screen. Do, 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 do. There it is. Okay, so let's get to it. I made a new set of questions, and we're going to start off with some agency questions. And yeah, you're just nervous? Ah, the nerves, the nerves. Just imagine you can hear my voice in your head. I don't know if that's a good thing or a bad thing, but imagine you can hear my my voice in your head and imagine like we're walking through the question together. And I know you've got this. And even if you don't, we're going to get it. So it's cool. We got this. All right. Let's go on to our first question. This is a new set. It's going to be a mix. It was 40 questions. But as always, if you have questions, feel free to ask them, get clarification, even if it's just so, we can follow more on the topic. So here we go with question one. A buyer's agent discovers a material defect in the property during a showing that the seller has not disclosed. What is the agent's primary obligation? Is it A, immediately inform the buyer and document the disclosure in writing? B, report the defect only to the listing agent and allow them to handle it? C, keep the information confidential since it could harm the seller's negotiating position? Or D, advise the buyer to make an offer contingent on an inspection and say nothing else? Well, we know here, the key here is that you've got this material defect. Let me change colors. Boom. This material defect. And I don't know of any agent in any state that has the ability to not share a material defect. And we notice that this is a buyer's agent. So that's going to be important because even if it wasn't a material defect, you're there, you represent the buyer, you give that old car, that loyalty, the confidentiality, that obedience, all of those things to the buyer. So, having said that, we know that we can eliminate C. We are not worried about protecting the seller's negotiating position, right? And this problem D, say nothing, that's not going to work either. Which leaves us with two, report the defect only to the listing agent or immediately inform the buyer and document the disclosure in writing. Well, B's not right because you don't just tell the listing agent, you got to tell those material defects to your client. So our answer, as you said, Miss Caroline, is definitely A, immediately inform the buyer. And the key part here, document your disclosure in writing. More than likely, most states, you're not going to have a law that says it has to be in writing, but CYA, cover your assets. Make sure you put these things in writing so when that person comes back and says, you never said that, you're like, oh, but yes, I did. See how I sent it in this email? Or you signed off right here? Because I hate to say this phrase, buyers are liars, because it's not very nice, but sometimes buyers and sellers can be liars. They don't mean to be, they just forget. All right, let's try number two. Which of the best describes the legal concept of constructive notice in real estate? All right. So, A, actual knowledge of a fact communicated directly to a party. B, notice that the law presumes a person has because notice that the law presumes a person has because the information is publicly recorded. Wordy, but okay. C, a verbal notice given by a seller to a buyer during negotiations. Or D, a notice placed inside of the property that a buyer is expected to find during inspection. All right, so we know, let me just see here. I just want to take a look. Oh, right, cool. We know our answer is going to be, of course, B. There we go. We know it is B because we've got the publicly recorded. When you record things at the Register of Deeds, you're giving constructive notice. Right? We're giving constructive notice, and we know the answer is not going to be A because this is actual notice. Actual notice. You actually communicated it to somebody, right? And I guess in theory, you could say maybe C if you verbally told somebody something, but again, you probably want to put that in writing. B is our answer for number two. All right, let's try number three. A seller instructs their listing agent to tell buyers the roof was replaced 5 years ago, when in fact it was replaced 12 years ago. The agent complies. Which party or parties may be liable for misrepresentation? Is it A, only the seller because the agent was following instructions? Is it B, both the seller and the listing agent? Is it C, only the listing agent because they made the statement directly to the buyer? Or is it D, neither party because approximate age statements are not considered material? And I see you, Miss Caroline. You said our answer is B, and you are absolutely correct. Both the seller and the listing agent. You can't lie on behalf of the seller. You just can't do that. No, that's going to be a big fat no. We don't do that. All right, number four. We are flying through these. Under what doctrine does a court treat real property as personal property when a deceased owner had clearly intended to sell it before death? Mm. I've never seen this question before. Let's see if we can work through it together. Under what doctrine does a court treat real property as personal property when a deceased owner had clearly intended to sell it before death? We're going to treat the real property as personal property when the owner had clearly intended to sell it before death. Okay, well, if you clearly intended to sell it before death, I'm assuming there was a contract. So the doctrine of equitable conversion, the doctrine of adverse possession, the doctrine of equitable subrogation, or the doctrine of merger. Well, I don't have any clue. Let's see if we can work this through. I know it is not B. There's no doctrine of, I mean, I don't think it's called a doctrine, but adverse possession. Nope, that's where you get to claim property is yours if you can prove that your use was open, continuous, exclusive, actual, notorious. Okay. What else can I eliminate? Oof. I think I can eliminate C because subrogation means to, we've got the it's when you pass on responsibilities to somebody else, but you're passing on a responsibility. I don't think it has anything. I think this equitable subrogation doesn't sound right. And the doctrine of merger, I mean, you're not merging anything. So I don't think that's right. I'm going to go with equitable conversion because maybe we're converting it from real property to personal property. Yeah, you know what, Caroline? I'm kind of going with A2. I'm like, what? Who? What is this? Now, I'm pretty sure it's not B. I'm pretty sure it's not C. I've got to gamble 50-50 between
Yeah,
A and D.
that was my thoughts because real property and personal property are being converted together. So
Yeah,
that's why I came up with the equitable title, or not title, but conversion
yeah,
as
that's
well.
That's what I'm going with too. Okay, we're gonna go
Yeah.
with A. Let's see. I gotta pull up the answer. I'm like, oh no. Let's see. Number four is the answer. Our answer is A. Hey, we got it right. We got it right. Hey, we got it right. Okay, let's see what it says. What answer does it give us? It gives us, why not D? The doctrine of merger holds that the lesser interests merge into greater ones. Okay. That the lesser interest merges into a greater one, which is unrelated to that scenario. A lesser merger interest merges into greater ones. I don't even know when that would come into play or what that exactly means, but okay. And we know subrogation is going to have to do with creditors. All right, we're good. We're good. And we learned something. Do I think the doctrine of merger, the equitable subrogation, or even the equitable conversion are going to be on your test? Probably not. If it does, that's the beauty of taking random questions. That's a point for you. But I do know that you should know adverse possession for your test. That is something that is highly testable. And for that, remember, we're going to know ocean. And that means your use was open, continuous, exclusive, adverse, and notorious. Right? So there we go. All right. I mean, I guess they didn't play. I asked AI to do hard difficulty, and Claude was like, okay. Claude was like, you get what you asked for. There you go. All right.
Does,
Go ahead.
does adverse possession run with the land, or am I saying something else?
I think
I,
you're thinking of something else because
okay,
adverse possession.
appurtenant, I think.
Well, you're thinking of what?
Appurtenant, maybe?
Appurtenant means run with the land. Yes.
Okay, that I got them
Appurtenant means
confused.
run with the land. Yes. But
Okay.
there is the A and the P and stuff like that. Appurtenant. Or appurtenant. Appurtenant is how it's supposed to be said, but I just don't like that. I think that sounds silly. Appurtenant. Sounds more pretentious. All right. Question number 5. But I love the fact that you knew appurtenant. And you know what are appurtenants? You know, you have appurtenant easements. Your rights are sometimes appurtenant because they run with the land, right? So there are times when there are things that are pertinent, but not this one. Number 5, a property is encumbered by a mechanic's lien and a mortgage. The mortgage was recorded first. The owner then sells the property, but the lien is not paid. Which statement is correct regarding priority? Okay. A property is encumbered by a mechanic's lien and a mortgage. The mortgage was recorded first. The owner then sells the property, but the lien is not paid. Which statement is correct regarding priority? So I'm assuming the mortgage was paid off, but we still have this mechanic's lien. Let's see. A, the mechanic's lien takes priority because it protects labor and materials. Okay. B, the mortgage takes priority because it was recorded first under first in time, first in right rule. C, both the mortgage and the lien share equal priority and proceeds are split pro rata. Or D, the buyer takes the property free of both encumbrances because of the bona fide purchaser rule. Well, I know this. It's not you got it property free of both encumbrances. That's the whole part of a lien. It can't be that. Can't be that. All right. And both the mortgage and the lien share equal priority and the proceeds are split. No, I know that's not true. It says the mortgage was recorded first. So sells the property, but the lien is not paid. Okay. Well, maybe they're talking about the mortgage lien. Either way, if the mortgage lien was paid first, it would be, well, if the mortgage lien was recorded first, it needs to be paid first. That's the whole point of first in time, first in right. Right? And it's not that mechanics liens take priority. You know what does take priority? Real property tax liens. That's an R and a P. Real property tax liens would take priority. So for 4, I'm going to go with B. Let's see if I'm right. Okay. Okay, Claude, I see you with these harder questions. Let's see. Hey, we got it right. We got that. All right, number 6. Wow, I'm impressed with Claude asking for the difficulty, hard difficulty. This is making me think. These aren't just the regular ones you see all the time. And hello, Georgia Richardson. I see you there. I see you there. I wasn't sure what your answer is. I see you put A in for answer. I wasn't sure which one that was, but hopefully it was for question 4. All right. Let's see. Question 6. Which of the following is an example of a general lien? Okay. Which of the following is an example of a general lien? Is it A, a mechanic's lien placed on a specific property after the renovation work? B, a mortgage recorded against a specific parcel? C, a judgment lien entered against a debtor that attaches to all real property in the county owned by the debtor? Or D, a property tax lien assessed on a specific parcel of unpaid taxes? Now, they did try to give you a hint there. They had the word specific, specific, specific. And we know we got 2 types of liens. You got general liens and you have specific liens. And we know specific liens are on one piece of real property. All of these, the D, the B, and the A are all specific, specific, specific. Those are all specific liens, meaning our answer has to be C. That is going to be our general lien. Hey, I see y'all getting this right. All right, question 7. Which clause in a mortgage? Shocker, they're asking us about mortgage clauses. If only somebody had told us we were going to need to know these mortgage clauses for the test. Yes, I am being facetious. We know we're going to need to know these mortgage clauses. I digress. Which clause in a mortgage allows the lender to demand full repayment of the loan balance if the property is sold or transferred without lender approval? Now, I know we had a similar question to this on Sunday. This one is just worded a little bit differently. And there is something to, you got to know what you know. If you know, hey, I know the clauses in a mortgage lien, and I know that 2 of them demand full repayment. We know 2 clauses demand full repayment. We know one is the alienation clause or the due on sale clause. And we know the other is the acceleration clause. Well, alienation or due on sale clause is because you sold it. So we know that won't be the answer. And the acceleration clause says, hey, if you default, or I guess actually it is the answer because it says property sold or transferred without lender approval. Acceleration clause means you defaulted. You defaulted on your payments. So we know the answer has to be alienation or due on sale. And oh, what do you know? It's right here. We know that B is our answer. But do we know the definition of defeasance clause? Do we know the definition of a prepayment clause? Do we know the definition of a subordination clause? Well, the subordination clause says the mortgage is going to be first. When it comes to recordation and getting paid off, that mortgage is going to be first. Nothing should come above it besides property taxes. The prepayment clause is that you owe the bank some money if you pay off early. They're trying to make money. And the defeasance clause says, hey, bank, when I pay you off, I want title back. Those are part of those clauses you need to know for the test. Make sure we know them. Hey, hello. I see y'all saying hey. All right. What am I doing? Oh, question number 8. A tenant has a month-to-month lease. Okay. The landlord wants to end the tenancy. In most states, the landlord must provide a minimum notice of how long? It's a month-to-month lease. What are we thinking? Well, this one, it could be a national question, but I would guess that most of us would get this question on the state-specific side. I mean, this is pretty standard, but let's see. If it's month to month, I'm going to say it's not probably going to be 90 days. It's month to month. All right. What I go with here is, are they saying that it's like 30 days and then they're going 30 days? I'm going to assume that's what they mean because we know there's different types of estates. You have your, oh, these are called non-freehold estates, right? We have our tenancy, gosh, what's it called? Term. It's an estate for term. Look at me, it's racking my brain. We have an estate from period to period. We have an estate at will, and we have an estate at sufferance. So an estate for term means it's not going to automatically renew, which means we are talking for a period to period. And since they're saying month to month and not period to period, I'm assuming it's 30 days to 30 days. So I cannot imagine that they're going to make you give 90-day notice or 60-day notice. The question is, if it's a 30-day month and you're going month to month to month, how much notice would you have to give? I'm going to guess you're going to have to give 30 days. That's going to be my guess. I don't know though. All right. In your state, it's 30 to 60 days. Yeah. Okay. All right. And we got B. So see the B, the 30 days. All right, guys. I'm assuming, again, it says most states. I know a lot about a lot of states, but since this is a national question, I'm going to go with 30 days, right? Because it's 30 days. If it was a week to week, we might have to give something else, but I'm just going to go with 30. That's what my gut's saying. Oh no, I could be wrong. Looking at the answer, let me find it. Hey, the answer's B. The answer's B. Hey, the answer's B. All right. And it does say in the notes that this is typically 7 days for week to week. That's typically right. Now, if we were in North Carolina, I would tell you that this is different. If you were a North Carolina person and you had to take this test for North Carolina and it was on the North Carolina side, our numbers are different. But this says in most states, and that would be tricky if you're a North Carolina person. Yeah, that one's hard. But good guessing, y'all. Good guess. All right, question 9. Under the Americans with Disabilities Act, ADA, which of the following properties is most likely required to make reasonable accommodations for access? So, which one is most likely required to have to make reasonable accommodations? And this is under ADA. Is it a single family home rented by an owner occupant? B, a commercial retail building open to the public? C, a duplex where the owner lives in one unit? Or D, a private club that restricts membership? Hmm. What are we thinking? You know what? I'm thinking that if it's a single family home rented by an owner occupant, like you are living in it and you have a roommate and the roommate's like, I need you to do A, B, C. I'm thinking you're going to fall under the exemption. And the same thing, if you're restricting membership, there's the exemption, and that's under fair housing. But this is talking about ADA. And I know the ADA talks about commercial spaces, not just rental spaces, but in the duplex where an owner you lives, and a private club, and a single family home, those aren't commercial spaces. So I'm going to go with B, and I know that's the right answer. A commercial retail building open to the public. Remember, Fair Housing Act. That's about housing. The ADA is making sure the public, everybody in the public, has access, or at least try to make it so more people. So since there was private, 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 I'm going to go with that one commercial, and I know that is the right answer. 4-9, our answer is B. Okay. Now, I will say it generally talks about making things in the public. The ADA says some other things as well. All right, question 10. Oh, back to agency. An agent represents a buyer. During negotiations, the seller asks the agent directly, how much will your client really pay? How much will your client really pay? The agent should, all right, you are a buyer's agent. The seller is asking the buyer's agent, what do you think the buyer's top price is? Seems to me that's the kind of stuff you're supposed to be keeping quiet, my fine sir. That's not the stuff that you're supposed to share. Mm-mm, mm-mm. So, answer honestly because full disclosure benefits all parties? Absolutely not. B, decline to answer because disclosing the buyer's maximum price would breach fiduciary duty. I like that. C, refer the seller to the listing agent who is obligated to answer the question for them. I should hope that the seller's agent doesn't know what the buyer should really pay. Why were you telling the seller's agent that? That sounds crazy. No problem, Miss Val. No problem that you're late. You're not late. You're right on time for you. And then we got D, offer a range to satisfy the seller without fully disclosing the buyer's limit. Uh, I mean, D sounds like it could possibly work, but no. I mean, unless you give a range of $100,000 on a house that's, less than $1 million, no, I don't think the range. This is where choose the best answer comes in. Could a range maybe get you to where you're trying? Maybe, but that's not the best answer. Our best answer is definitely B. Don't answer because you could be breaching or you would be breaching your fiduciary duties that you owe to your buyer client. Boom. All right. I see y'all answering YouTube land. I see y'all answering this right. All right. 10. Wait, you know what, Caroline, before I go on any further, were there any topics on agency that did you want me to go over anything? I know you're getting close. Do you want me to go over real quick the types of agency or anything in general, any aspect of agency you've been struggling with?
I'm sure I do. Just give me a minute. I have to think about it.
Yeah, think about it. And that's for anybody. I'm asking Caroline because I know she's going to test soon. But if any of you all, while we're doing these questions, if you want to, like I talked about adverse possession, I go over it a little bit, but you all are always more than welcome to say, can you explain that some more? That's why you have a live teacher. That's what I do. Alrighty. Moving on to number 10, but Caroline, just holler, or anybody holler if you want a topic explained. All right, questions 11 through 20. I don't know why it split it up like this, but sure. Which type of listing agreement gives the broker the exclusive right to sell the property and receive a commission regardless of who procures the buyer? All right, Claude. Claude, I'm going to need you to not put the answers in the question. What day are the lives? The lives are on Wednesdays, and they're on Sundays at 7 p.m. Eastern. And just a reminder, everybody, if I get enough people on TikTok, which is at Canned Ellis, I will extend our Sundays to be more like 2 hours instead of an hour. So go TikTok it up, y'all. We got to get enough people to go live on TikTok. All right. So which type of listing agreement gives the exclusive right to sell the property and receive a commission regardless of who procures the buyer? Thank you. Master of the obvious. It's obviously the exclusive right to sell listing. It's not a throwaway question though, because do we want to make sure we understand the difference between the exclusive right to sell and all the other types of listings? Yes. Remember, if it was just exclusive agency, If the seller finds the buyer, then you get no money. You get no money. No money to you because that's the whole point of the exclusive agency listing. Only one broker is listing the property, but if the seller finds the buyer themselves, no compensation is due. Well, then we got this open listing. An open listing is the opposite of either of our exclusive listings. There's no one broker that's been tasked for marketing the property. In an open listing, any broker that has the agreement with the seller, there can be more than one, can market the property. The only person getting paid is the broker or the agent who finds that actual buyer. And so that's a lot to put in. I'm going to say the opposite of exclusive. That's not how you spell exclusive. Call it exclusive style listings. And then we know a net listing is when the seller says, hey, here's my bottom line. I want to walk away with $200,000, and anything greater than the base is your commission. And in some states, we know that is illegal. So, easy question, better study tool if we make sure we understand all of those different words. All right, question 12. A property management agreement is signed. Which of the following is the property manager in relation to the property owner? Or a very fancy way of saying, what type of agency is the, average property management agreement? Is it universal agent, general agent, a special agent, or a sub-agent? Hmm. Hmm. Caroline, I think you said, or was that the answer from before? You said C before. Are you staying with C? What do we think? If you're a property manager, what type of agent are you? Universal agent, general agent, special agent, sub-agent? Hmm. Yep, C. I see you there. I see that. Yeah, well, no, you said C, but C is actually not the answer. Doop. I was just so excited, but C is not the answer. Our answer is B. Our answer is B, but let's talk about why. Why is our answer B? Because we know a universal agent is like a power of attorney. You get I don't say full rights, full permissions, we'll call it that, to do whatever it is you want to do. You can make your own independent decisions. The opposite of that would be special agent. And this is what we are if you're in sales. If you're in sales, you're a special agent because you can make no independent decisions. But if you're a general agent, you get to make some independent decisions. Let's give an example of that. If you are in sales and you're somebody's seller's agent, you don't get to decide how much the house is going to go on the market for. You can make a suggestion to your seller, but they don't have to, do it. Right? That's because you're a special agent. You must follow direct instructions. If you're a universal agent, you're somebody's power of attorney. That means you get to make independent decisions based off of your thinking, what you think is going to be best for your client. But a general agent, if you have an investment property and they're, helping the renters that you have there, that's why you have that property manager. You want them to make some independent decisions. When that tenant's like, oh, my hot water heater's not working, the whole point of having a property manager is that that person will probably have the ability to go out there, assess the damage, and if they think fixing it or repairing it is going to cost under a certain threshold, they get to make those decisions, make sure it gets done, and then deal with it later. They have some level of independent decision making. So our answer for property management is going to be general agent. All
Can
right.
I ask you a
And
question?
yeah, go ahead.
So would a special agent be considered a licensee agent?
A what type of agent?
Licensee, a real, meaning not the broker, but a regular real estate agent. Would that be a special agent?
Yes. So
Because-
it's more about, this is more about your abilities to make decisions. So
Right,
whether it's the broker or the salesperson, if you're in sales, you don't get to make your own decisions.
right.
Even if even if you became once get licensed, if you decide to become a broker and not just
Mhm.
a salesperson, right? Or if you become a BIC and not just a full broker, if you are somebody's in North Carolina. All right, then it doesn't matter if the seller tells you to list the property for this much. If the buyer tells you, "Hey, I know it's really low. Let's offer 200,000 less than asking." You as a special agent, whether you're a broker or a, salesperson, you don't get to make any independent decisions. But general agents do. So, as the general agent and as a property manager, you might decide between, oh, this rent's going to be 1,200 a month versus it's 1,220 a month. Those are the types of decisions you get to make. You know what? I've decided to replace this shower head versus try to have it fixed. There are some independent decisions where you don't need to go back to your client and say, okay, what do you want me to do? In fact, that's why they've hired you to be the property manager. Does that make sense?
Yeah, it does. Yeah. We
Cool.
basically don't want to call at 2 o'clock in the morning that the air conditioning unit is not working.
Exactly. That's why you have a property manager. That's why you're paying them for them to deal with it. Now,
Right,
usually
right.
in a property managing management contract, you will
Mhm.
have some limits. So it'll say something like, you know what, property manager, you can make decisions about fixing stuff uh, up to $2,000. But the minute the fix costs more than $2,000, you need to reach out to me.
Right,
Right.
right.
So
That makes
some
sense.
independent. Hey,
Okay, thank you.
you are very welcome. That's why we're here asking questions.
Okay,
All right, Miss Carol.
Candace,
Yeah, go ahead.
I do actually have some stuff in agency, like the
Mhm.
TILA and RESPA and the Sherman laws.
Okay. That's not necessarily agency, but let's go over it real quick. You said you
Yeah,
had a
because I get
question.
confused on that stuff.
All right. You had a question on
Yeah,
TILA
yes,
versus RESPA,
yes,
which I'm assuming versus TRID.
yes, yes,
Okay.
exactly.
All right. Well, let's go over it real quick because this is always a question. Do you know what TILA stands for?
Yes, Truth in Lending Act.
And if you had to sum it up, what would you say it says?
Um, Good question.
Okay, it says truth in lending. Who do you think needs to be truthful to whom?
The lender.
The lender
Yes,
Hmm.
has to give truth to the buyer. And this is where you also get into Regulation Z, right? Regulation Z is another name for it. And we know this is where if you're advertising, if a bank is advertising a loan, they want to give they can say the APR, but they're also going to have to give other info. So this is when you think of TILA, you can think of like car advertisements where they're like, you can have a wonderful December to remember with 0% financing. And then they're like, and all that fast talking or the small words at the bottom of the screen is because TILA says, Dear bank, if you're going to advertise that somebody can have this car for 1% down, you need to give them the details. Oh, that was for $40,000 for a 5-year loan. And they put down, their payments are this. And, this was their credit score. They have to give more information. That is truth in lending. It tells you exactly what it is. Lenders have to be truthful. Does that make sense? Hopefully.
Yes, thank you.
Cool. All right, we got that one. We change colors. RESPA. Can I make this clear? RESPA. Ooh, that's too thin. Oh, now, gosh darn it, Candace. Me and my crazy brain. Let's make that a little thicker. Boop, boop. So too thick. Boop. There we go. Do you know what RESPA stands for? You know what? I'll just help you out. It stands for Real Estate Settlement Procedures Act. And so once again, it's telling you what it has to do with. Truth in Lending said, I need you to be truthful. Lender. Real Estate Settlement Procedures Act, take a wild guess what it has to do with. Settlement. This is the young kids eat up boogers, boogers. What is it? I can't even think of my own saying. Young kids eat up boogers, glue, and dirt. Right? We know that RESPA says when it comes to real estate closings, certain things have to happen. Young kids eat up boogers, glue, and dirt. And instead of trying to write all this out, I'm going to bring up a picture of what that stands for as soon as I find it. That would be in my, where is it? Boom. And I know you've seen this before. Our acronyms list. Here it is. RESPA requirements. Young kids eat up boogers, glue, and dirt. RESPA, we know that S stands for settlement. And we know that really has to do with closings. When it comes to real estate closings, real estate transactions, there are some laws. We know that if there is a yield spread premium, it has to be returned to the buyer. Sometimes banks would say, hey, mortgage broker, if you can get this buyer to take a higher interest rate, we'll kick you back some money. And RESPA says, absolutely not. Broker, if you're going to get extra money because the buyer pays a higher interest rate, which could literally cost them tens of thousands of dollars, that little bonus you're making, that needs to go right back to the buyer. We can't have kickbacks. So you can't have anything where, oh, you know what? Every time you send somebody to me as the attorney or the title company or the inspector, I'll give you some, a cut of whatever I charge them. That is a no-no. Escrow account restrictions. We know that when you pay a mortgage, you pay PITI. And we know this T&I is for taxes and insurance. And we know these go into an escrow account so the bank can pay those bills later. If your tax bill is, let's say, $4,000 a year, they can't have you put $6,000 into a trust account, like into that escrow account. Absolutely not. Do they need to have a little padding in case taxes go up? Yes. But there's certain limits to how much they can have you put in that escrow account so that they can pay the bill later. So that's the E, escrow account restrictions. The U is for uniform closing statement. It doesn't matter if you help somebody buy a house in Hawaii or you help them buy a house in Michigan or California. If they are getting a loan, they're going to be using the CD. It's a standard closing statement. So even if I've never seen a closing done in New Hampshire, I could read that closing statement. I could tell you where the down payment is amount. I could show you what the sales price is. I could show you what the loan points are. We all use the same form to close. We know HUD makes a booklet. That's the B here. They make a booklet going over mortgage basics for the general public. And the lender needs to make sure they give that to the borrower when somebody applies. The good faith estimate, the GFE, just like they need this booklet, they need to be given an estimate within 3 days of applying of, hey, what do you think these numbers are going to be? Give me an actual estimate. It's got to be within a certain amount of accuracy, but they've got to say, hey, I think your PITI payments will be this. I think the points we're going to charge you are going to be this. I think your loan origination fee is going to be this. It's an estimate of the fees they think you're going to have to pay, and it must be accurate, pretty close to being accurate. Can't be, it doesn't have to be 100% because some things change depending on like what day you close, but needs to be pretty accurate. And then the D is for loan disclosure of loan servicing. That means that bank, if you're going to have another company collect the monthly PITI payments, PITI payments, you have to disclose that. If somebody's getting their loan from Wells Fargo, but they've hired, I don't know, they've hired LMNOP as a company to collect your monthly payments, they have to actually tell you. So young kids eat up boogers, glue, and dirt. That's RESPA. It has to do with closings, real estate closings, real estate settlements. We've got some laws to protect those people who are buying real estate. All right. So RESPA is our young kids eat up boogers, glue, and dirt. Ooh, get our letters there. No problem. And then TRID stands for the TILA. Oh, let me change colors. Boop. Erase this so that you can take a screenshot. It is the TILA RESPA integrated disclosure. TRID. All right. And we know TRID basically says we needed to kind of merge TILA and RESPA. Both of them had their own particular things, and it was causing a lot of paperwork. So let's just use one set of paperwork, or, you know, I'm not going to say one set, but they're merging the paperwork so that you don't have to have duplicate documentation. So like we know we had to get the good faith estimate. Remember this, the good faith estimate? So that good faith estimate, which you have to get 3 days after applying. Well, it turns out TILA said you had to have an early TILA statement, which guess what? You had to be truthful about what you thought the costs were going to be for the loan. Both documents said, hey, you need to tell the buyer or the borrower after they apply for a loan what you think the amounts are going to be. Why do we have two different sets of documents, two different things saying the exact same thing? That's not going to work. We're just going to use one document and call it the loan estimate. Right? Let's save on paperwork. And then the same thing, you know, you had to have a settlement statement. And you know, over here, you had to have a final TILA, a final breakdown of what all the costs were. Two different documents saying the same dang thing. So instead, they created the closing disclosure. That says disclosure, you just can't tell. But TRID is a mix of TILA and RESPA. Did that help, Miss Caroline? Yay! So if you want to make a screenshot of that, even though my handwriting is awful, you are more than welcome to. And if I need to go back to the other screen, I can as well. But that is a review of just TILA, RESPA, TRID. Cool. Then you did ask another question before you came up with that. You said, doesn't have anything to do with agency, but could I go over meets and bounds, lots and blocks, and then the survey system? Sure, I can do that today. If unless somebody has a problem with that, and if what you do, I don't know what to tell you because it's a free class. We'll come back to some questions, but it doesn't hurt anybody for us to go over meets and bounds, lots and blocks, and survey system. So let's come here to some slides that I'm sure I have in here somewhere. Boom. And let me find it. Now, this section, what you are talking about are legal descriptions. Right? You know that in order to sell a property, you're going to have to say, I'm giving that person the house. Which house? I need more information than that. In a deed, you know you have to give a legal description. And we know we've got 3 different basic ways we could do this. Meets and bounds, government rectangular survey system, or the lot and block system. Which, okay, seriously? Did my page just do that? Yes, it did. There should be a button that says, go back to where you just were. Stupid thing. All right. You got the meets and bounds. You got the government rectangular survey system, and then you have the lot and block system. So, meets and bounds. This is where, and I'll use this picture. This is where a surveyor says, and find a good color here, hey, I'm going to start at this point of beginning. I start at this point in beginning, and I'm going to tell you to go a certain amount of feet to a certain point, and then I'm going to tell you to go another amount of feet to a certain point, and then I'm going to tell you to go another amount of feet to a certain point, and then another amount of feet to a certain point, and then another amount of feet to a certain point right here. And they say, okay, well, if I've given you all this information, everything inside of the shape we made, that is the property that's being sold. So you must start at the point of beginning and you got to end at the point of beginning. And this can either be written out or it could be in a map. They can do it either way. And this is the oldest form of how they would describe a piece of land. Right? And it's what you're doing when you get a survey, right? So let's say that this was the point of beginning. You can see they went 226 feet northwest, and then they got to this point, and they went 60 feet northeast, and then they got to this point, and then they went 151 feet southeast until they got to this point, and then it curves to the road, and I'm sure somewhere on here it tells you where that measurement is. I don't know. But that's what you're trying to do. Oh, the C1 curve, look. It tells you there's the radius, there's the length, there's the delta, blah, 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 blah. All way too much geometry for me. But when you get a survey, they're telling you what's inside, right? What's inside this area you created. All right? So that's your meets and bounds. It's your oldest way of doing this. It's what we do in a survey. And you know, in a survey, you can see things like where's the driveway, where's the house. Can you see, like you see right here, this is saying, oh, look, somebody's fence is encroaching. That's what that is. All right. Then we've got... Scroll. That's a plat. You got the block and lot system, right? And the best way to show you this is right here. We know a plat is a subdivision map. It's a map of a subdivision. So let me actually scroll here. This is a real plat for a real subdivision in North Carolina. And you see these similar in new home construction, right? If you walk into a new home construction, you'd be like, oh, I think I'd like to purchase lot 33. And there's a map. And the plat is a map of all of the lots in the subdivision, So a plat is a survey of all of those lots. And then we give it a number and we can say, oh, this is lot 33. These get recorded, and I'll try to blow this up for you, at the Register of Deeds. This one is in Johnston County in North Carolina, Plat Book 87, pages 4 and 5. So anybody could go to Johnston County, North Carolina, go to the Register of Deeds, look at Plat Book 87, go to pages 4 and 5, and find lot 33. That's going to be referring to an already recorded document. That is going to be your block and lot system, because you had lots. And in cities, you talk about a city block, right? So all of this blue is the whole block. And then you got a lot in a block. It's a lot and block system. And then our third way of measuring everything is the government rectangular survey system. And this is where we get our acre. You know, we need to know that there's 43,560 square feet in an acre. I love my t-shirt that says that and my stickers. And I'm going to get a hat that says 43,560, but that's a whole different story. And sorry, these are my slides I teach with. So we know that it's most of the United States, except for really the East, like the oldest states, like the original 13 colonies in Texas, they don't use this. But most of the rest of the states say, look, we got these imaginary longitude and latitude lines, and there's going to be 2 in every area that cross. So let's say you're here. If you're in North Dakota, you base where you are, what your piece of land is, all the way to where this principal meridian and baseline cross. I do not know why we have these certain colors, or like why, you know, you got all these states with this one. But then look, Michigan's got its own. It's just Michigan. But then, you know, Ohio's got its own. But then you look at something like California and it's got 3. I do not know. I have no idea why it happens this way, but it does. But every time you see, and then Florida's got its own, every time where you see one of those 2 crossed lines, you're giving, oh, well, how far is my piece of land to right here? So, and this kind of shows you, this was Arkansas, and so it's got a principal meridian, and it's got a baseline. They each have a number, and you can identify. Right? So we know you have a baseline. It goes east to west. You know you have a principal meridian that's going north to south. And what we do is we say, hey, there's imaginary lines that come off the principal meridian every 6 miles. So this is a principal meridian, and this is a principal meridian, and this is a principal meridian. And you have baselines that go, you have your baseline, but then you have tiers right here, right here, right here. Those are tiers that go every 6 miles from your baseline. And it creates a 6 mile by 6 miles block of land called a township. And since it's 6 miles by 6 miles, we would have 36. I mean, that's 6 miles by 6 miles. That's 36 square miles. I mean, 36 square miles, 36 miles square. Yes, I think I said that right. But that's a lot of land. So we know we take that 6 miles by 6 miles and put it into 36 sections that are 1 mile by 1 mile. And we start here with 1, and then we go 2, 3, 4, 5, 6, and then we go down 7, 8, 9, 10, all the way to 36. So you have these 36 sections that are all 1 mile by 1 mile. Every section contains 640 acres. And since that's a lot of land, what we do is take it and split it into quarters. So you would have a quarter of this 640 acres, which would be right here. Look at that. So that would be the northwest quarter of section 36. That's still 160 acres. So what do? We quarter that. And now a quarter of this would be a quarter of that first quarter of all of a section. And that's still a lot of land. So what do? Nope, that's not what I wanted. We quarter this. And then you'd have a quarter of that, which is 10 acres. And that's still a lot of land. So what are we going to do? We're going to pick a different color. That's the first thing we're going to do. And make it a little smaller. And that's where you have here. And then this will be 2.5. You keep quartering it. So when we talk about the government rectangular survey system, one thing I like to say is we're basically turning the land into graph paper. We're making these squares. And we got these 6 mile by 6 mile townships, which then get split into sections. And each section, which has 640 acres, gets quartered. And it's a lot because the whole, do I have a picture of it here? This is an old picture of, Detroit. I don't know if there's a year on here, because y'all know that's where I live now. Detroit, is there a year? I don't see a year on this, but that's okay. This is real. And you know what? You all have seen the movie 8 Mile. 8 Mile is the baseline in Michigan. And where I grew up, should be somewhere around here. I grew up in Southfield. And now I live someplace there's Redford. I live someplace like 10 mile, like over here. I didn't move back home. But if you hear 8 Mile in Detroit, you got 8 Mile, you got 9 Mile, you look 10 Mile, right? You've heard about Grosse Pointe. Grosse Pointe is so old, part of it has the government rectangular survey system, and part of it doesn't. Some of Detroit is so old, it was on its own little system, but it's not as old as like Massachusetts or North Carolina. It does not get, those states don't have the government rectangular survey system, but a lot of states in the United States do have it. And so there you go. Remember, your baseline goes there, your principal meridian is here. You got tiers that go this way, and you got ranges that go this way off the principal meridian. And I think that's it. I could do this a lot, and I know it's after 8. Miss Caroline, did this help? Was that what you were looking for as
Yes.
far as a review?
Yeah, I took a lot of the screenshots and it helps me a lot.
Oh,
There's a
yeah.
lot to it. So,
And I want to say, if you email me, I think I have on my page a review of, I do on my YouTube. There's a video where you're going to see these same pictures on my YouTube. On the use of the tubes, it'll say government rectangular survey system.
oh, okay.
And I think it's about 10 minutes long. You'll see a lot of those same pictures, but I'll break it down. So you don't have to remember it. Just YouTube, on my YouTube, you can watch that video. I force my pre-licensing students to watch it. So it's explaining all this. It breaks it down a little slower. But if you still have questions, you can come back on Sunday and ask them. And then on Sunday, we'll also finish those 40 questions we started today, because you're getting so close. Your time is so close.
I know.
Right?
I'm getting
Yeah.
nervous, but you know what? It's just a test.
It's just a test, and you're
Yeah,
gonna get it.
Just gotta remember
is-
that.
Just a test. And when you do get it, because you've spent so much time with it, you're going to actually understand. A lot of people pass this test the first or second time and they get out there and they've totally forgotten all of it. They didn't put any of it together. And when you get your license, you're going to be like, oh, I totally understand. You know, I'm not saying you won't be lost at all, but I'm saying you will know that you know. When it says encumbrance, when you see the word lien, I know that you're going to know what's happening. And at the end of the day, that's what I really want.
Well,
That's what I really want.
I
So.
appreciate it. I appreciate all your help, actually.
Of course, you know I love doing this. Y'all that put in the extra time to do this, this is why I'm here. Ask those questions because I want to make better agents. And plus, I'm just a real estate nerd and I like this stuff. So, if you all have questions, you know how to find me, email me, or otherwise, I will see you all Sunday. Let me make sure. This is my CE season, so I just want to make sure my CE doesn't bump into what I need to do with you all. Let me just triple check that Sunday. I think I'm teaching Sunday in the morning. Nope, I'm good. Yep, we're good. Sunday, I'm good. I'll be here at my normal time on Sunday after teaching CE all day. So I will see you all on Sunday. Have a good one, everybody.
Thank you.
Bye.
Bye-bye.